Thank you so much, Phil. So, hi everyone. My name is Kenny Matuszewski, and I am a member of the YLD. So, I practice patent litigation at a firm called Goldberg Segalla, and I have had actually the lucky privilege of having to do a few settlement conferences here in the Northern District of Illinois, particularly through the Pro Bono Settlement Assistance Program. We'll be discussing that a little bit more later on, and as a great way for young lawyers to get involved. But first, I have the privilege of introducing all three of our very distinguished jurists here today. Our first judge is Judge Beth W. Jantz. So Judge Jantz was an attorney with the Federal Defender Program at the Northern District of Illinois, which provides free representation to legally indigent people accused of committing a wide variety of federal crimes. Judge Jantz represented clients throughout the entire course of criminal cases, including trials and appeals. Before that, Judge Jantz practiced at Sidley Austin in Chicago, where she focused on class actions and products liability. Judge Jantz also clerked for the Seventh Circuit Court of Appeals Staff Attorney's Office. Judge Jantz has also served on many court committees and within several bar associations, including serving as the president of the Chicago Inn of Court for 2019 through 2020, the Board of Governors for the Seventh Circuit Bar Association, and as a member of the Seventh Circuit Criminal Jury Instructions Committee and the Seventh Circuit Advisory Committee on Circuit Courts. She's also taught and lectured both locally and nationally on e-discovery, electronic case management and review, and mobile and digital devices and data. Judge Jantz is a graduate of Dartmouth College and Northwestern University School of Law. Next, we have Judge David G. Bernthal, who's a graduate of the University of Illinois, where he received both his BA and JD. He spent 29 years on the bench, most recently as the United States Magistrate Judge for the Central District of Illinois, a position from which he retired in 2016. As a magistrate judge, Judge Bernthal oversaw thousands of cases in areas such as commercial litigation, civil rights, employment disputes, and intellectual property. He served as the Alternative Dispute Resolution Coordinator for the court and was a member of the Advisory Group of Magistrate Judges, a group of 11 judges across the United States who were selected to advise the administrative office of the U.S. courts. Following his retirement from the bench, Judge Bernthal served as a senior mediator and arbitrator with ADR Systems, one of the Midwest's largest alternative dispute resolution providers. In May 2019, Judge Bernthal moved his mediation practice to Weber and Tice, where he currently concentrates his practice in the areas of general litigation, mediation, and arbitration. Judge Bernthal is a member of the Champaign County and Illinois State Bar Associations, as well as the Federal Magistrate Judges Association, where he has served as a member of the Alternative Dispute Resolution Section Council of the Illinois State Bar Association and is a past member of the editorial board of the Federal Courts Law Review. And last but not least, we have Judge Brad K. Bleyer. And Judge Bleyer received his undergraduate degree from Southern Illinois University and his JD from Southern Illinois in 1982. Following his graduation, Judge Bleyer went into private practice, where for 21 years, he focused primarily in civil litigation, handling numerous jury trials throughout Southern Illinois. In 2004, Judge Bleyer was appointed to serve as a judge on the First Judicial Circuit of Illinois and was later elected. Judge Bleyer served as a judge for 16 years prior to his retirement in 2020, largely handling the civil docket in Williamson County, Illinois. He also served towards the end of his tenure as the presiding judge of that county. Since his retirement from the bench, Judge Bleyer has limited his private practice to handling mediations and arbitration at Bleyer Mediation. He is an approved mediator for the Southern District of Illinois. So with so many very qualified and excellent judges here today, well, I would like to actually go ahead and get started, particularly just by asking Judge Brad. So based upon your experience both now in private practice and as a time as a magistrate judge, what is a mediation and what is a settlement conference? And how do the two differ?
Kenny, was that for me? I'm sorry.
Oh, yes, Your Honor.
Okay,
That's
sure. In my usage of those terms, the settlement conference would be something that would most likely be conducted by the judge and by the court, whereas a mediation would be done by a mediator selected by the parties or appointed by the court. The difference between the two, I think, certainly, and Judge Bernthal, David, I think, knows this better than anyone. When you have, in his role as a magistrate judge, he handled a lot of settlement conferences. And when you have a judge conducting those settlement conferences, I think that judge has more authority, I think, to kind of push the parties towards a settlement than what you normally would see in a typical mediation. In a mediation, the mediator certainly has some authority, but is not deemed to have the same type of authority, I think, that the judge would have.
Interesting.
I would certainly agree with that. Sometimes you ask for what's the difference. I think there really is no difference, but I think the judge definitely pointed out what most people associate settlement conference with the court, mediation with a private entity, although our rules, at least in the central district, refer to mediation. But I think maybe the better way to distinguish is between court hosted and for hire, so to speak. And it's very true. And I just add to the simple advantage of the court hosted is it's free. That can't be overlooked. And there is a sense if it's conducted in the courthouse and the people got to tell their side of the story, even though there's no resolution or determination by the court, they at least get that sense of having had their day in court. If the case settles, I think there's a positive impact there. There is that power of the robe factor. I would hasten to, hopefully most courts have a policy of the trial judge will not be the mediating judge. As far as private mediators, sometimes you're going to have somebody who really wants to do mediation. They're a retired judge or they're an attorney who wants to emphasize that in their practice. Not all judges are keen on mediation. And if you happen to draw that judge, they're not going to have the same desire to really help the parties get it done. And they may have, the private mediator may have a little more time to devote to the case. That would be my 2 cents on that.
Thank you, Judge.
If I could, one of the things that I've seen come up on settlement conferences conducted by the judge, David mentioned that normally that's done by a judge that's not the trial judge. In some of the smaller counties, in the southern counties like I'm involved in, that's just not possible. So a lot of times you end up having a situation where the trial judge is being asked to serve as the settlement judge.
Yeah.
Issues there that attorneys have to really be careful about with ex parte communications with judges. And that's something as young attorneys, you've all been cautioned very strongly about guarding against, and the judges understand the rules there. It can be kind of tricky. You just have to make sure that the judge has gotten the okay and the approval, and everyone understands what the rules are going into that. And David and Beth, maybe you've dealt with some of those ex parte issues when you've done settlement conferences, but it is kind of a tricky thing that young lawyers need to be aware of.
And thank you so much for that, Judge Bleyer. So Judge Jantz, I would like to ask you, so now we know a little bit more about settlement conferences, mediation, nuts and bolts. the next question that I'd like to think is, so when should parties think of exploring alternative dispute resolution, such as mediation or settlement conferences?
I think in my experience, it's all across the board when it makes sense. There are cases when the parties know enough and have positions that are within striking distance of settlement that you can do it before you start discovery. And there are others where you need to get through the experts because there's such a dichotomy of a view on it that really having those expert reports and the depths help the parties come to some conclusion on where they might stand. So I don't think there's any one right answer in terms of case timing, but I think the right answer is the right time is when both parties are committed to wanting to sit down and willing to actually put numbers there on the table to start talking in concrete terms, not just if we'd like to settle it, but that the numbers are saying there's a shot at settling it.
Perfect. I think that makes a lot of sense. Just again, making sure that the parties are willing to have a good faith negotiation and go through this is just very critical. So I'm going to bring it now to Judge Bernthal. And I would like, just Judge Bernthal, I'm pretty curious. So what should attorneys know before they attend their first settlement conference for their mediation? And what, if anything, should they prepare and be prepared to discuss?
Well, that's a very good question. When I was preparing for today, I ran across an outline from a prior program in which an attorney from the EEOC was one of the co-presenters. And the very first thing under her list of do's, be prepared, be prepared, be prepared. And that's such a key point. And I think two things. The lawyer has to be prepared. And if the judge has entered an order or the private mediator has put out a request for a pre-mediation submission, that's not just make work. It's to help the mediator, but it's also designed to help the lawyer think about the case in a different way. So doing what's been ordered, and it's amazing, sometimes people don't do that. And I used to get very frustrated, and that does say order at the top there, right? But responding to that and taking the time to do it thoroughly is very important. But preparing the client is another thing. I've had a couple of situations where it was pretty clear to me that the lawyer and the client had no conversation prior to the mediation about what was going to happen. So the client has to understand that we're not going to get a decision today. They have to understand the process. And if there are little idiosyncrasies for a particular judge or private mediator, client ought to know that. Walk them through the process. If they're a plaintiff, make them understand that they're not just going to get a yes or a no. Make their expectations realistic. In other words, don't think that the other side is going to come in and apologize. I'm sorry that I brought this suit, or I'm sorry that I wrecked your car and hurt you. That's not going to happen. And or I'm just going to dismiss and hope you won't hold it against me. That kind of stuff. So I made a couple of more notes here. I think you have to make sure the client understands that they don't win in a mediation, in the sense that they might win at trial. They won't lose at mediation. And again, emphasizing to them that they are in control, that mediator is not going to dictate a result. The judge or jury might if they don't settle, but they're not going to win, they're not going to lose, and they have to be prepared to compromise. Compromise and capitulate, two different words. They have to be prepared to compromise, to accept less than they hope to get on a good day at trial, or pay more than they hope to have to pay if they have a good day at trial if they're the defense. So that preparation is is big. And if people come in unprepared, you probably aren't gonna go very far. One war story, hate to take too much time, but this was years back when I was early on the federal court, had a mediation. Plaintiff's lawyer, I kept trying to get a demand, or maybe it was a response to an offer, but I couldn't get a number. I finally said, okay, let's pretend that he's got his checkbook out and you get to write in the number. I think the person was a fairly new lawyer and just kind of it had a moment of panic. We didn't get anything accomplished that day, but again, maybe that reflected a lack of preparation, a lack of understanding with the client. Not only here's how this works, but here's how we're going to work. We're going to move here, there, and have a target range in mind, what we will find acceptable. So, long-winded, but I thought of all those things that I thought were worth sharing.
And I thank you for that, Judge Bernthal. I mean, it's very important actually, just because I remember hearing a couple of times actually from the judicial colleagues, actually Judge Harjani in the Northern District of Illinois, a couple of times I've had settlement conferences in front of him, was that no party ever walks away feeling like 100% happy when it comes to this. It's an outcome you can live with, but well, maybe you would have preferred something else, is how the best mediations and settlement conferences go.
I had this little cartoon and it had a little cat or something on it, but the caption was, a good compromise leaves both sides unhappy. And I put it on the table before we started the mediation, just to get people, maybe shifting into the right frame of mind. That's true. Your point is very valid.
I think somehow we'll have to circulate that little cartoon around. So,
If
Judge,
I could just add something just very quickly. The question kind of was prefaced, what should you know before you ever go into your very first mediation conference? And I would just tell young lawyers, don't be afraid to contact your mediator in advance. It can be an ex parte communication. That's what mediation is. So, if you've got any questions, call your mediator. We're more than happy to talk to you in advance and explain the process and answer any questions.
thank you for that, Judge Bleyer. So, Judge Jantz, at least within your courtroom and what a growing number of courtrooms, both in the Northern District of Illinois and across the country are doing, is that you adopted a standing order actually about having diverse and junior attorneys included more in courtroom proceedings. So how, for example, if say a young attorney is going to their very first settlement conference in front of you or in front of one of your colleagues, what should they do to kind of, maybe for lack of a better word, like at least like say use like the standing order to at least kind of ensure that they are heard while they're on the bench? And have you seen this like really succeed within your courtroom and maybe across the court so far?
So I would say I'm not sure. So a lot of our statuses at the federal courthouse here in Chicago are still telephonic. So I can't always tell whether we're increasing diversity or participation of junior lawyers. I would say in the settlement conferences, I've been doing this for about 2 years, so I don't have a huge baseline. I would like to see more diversity and more young lawyers being involved, because how do you know how to do something unless you do it the first time? But that being said, I've only done this for 2 years. So what is my baseline? A great program that you referenced, Kenny, is the Settlement Assistance Program. So if you're in the Chicagoland area, although really it could be farther out now because so much of the settlement conferences we do are by video, so location doesn't matter as much. You can actually volunteer to represent a pro se plaintiff for only purposes of settlement, which is a great way, one, to just do something nice for your community, volunteer, but also get good experience. Judges are going to be nicer to you. They know you're volunteering. They know you're not taking any money home. and my experience has been that our junior lawyers that do this really have good relationships with pro se plaintiffs. Generally, if they've gotten that far, the pro se plaintiff wants the help of the attorney, and it goes really, really well. So I would definitely make a pitch for that program as a way to get experience. Love seeing more diversity, more junior lawyers. It's on the Northern District of Illinois' website if you want to look for that, the Settlement Assistance Program. So that's one idea I have. TBD on if we're doing better in diversity and junior lawyers. It's a long range goal, right? And so I'm sort of thinking of maybe additional ways we can help with that. The jury's still out, no pun intended.
Thank you so much for that, Judge Jantz. And just so our audience members know, I think that there's a couple types of cases that are referred to the Settlement Assistance Program. I think it's prisoner civil rights cases and employment discrimination. So is my understanding correct, or has the Settlement Assistance Program expanded to certain types of cases it's taken on?
I mean, that's generally what you're going to see, because that's the most often types of cases in which we have pro se plaintiffs. But as far as I know, I don't think it's simply limited to that. But you're absolutely right. It's most often your Section 1983 cases, prison conditions, employment discrimination. Those are the most often ones I see. I don't know that there's a limitation. But your judges, if you're going to volunteer for this program, don't expect you to be an expert in these areas. We know you're not, and you're doing your service and you're volunteering. And so hopefully don't shy away, even if you don't know those areas. We have really good handbooks on our website that can help. So I would encourage you, from any background, please volunteer. It's fun, and it's a good way to get experience.
Thank you for that, Judge Jantz. I mean, and I can say as a patent litigator, I've actually handled a lot of 1983 cases through the Settlement Assistance Program, and it's very rewarding, and again, a great way to kind of use your skills and apply them in a different setting. So the next question I have, so actually now, Judge Bleyer, I will go back to you. So I would kind of thinking about, okay, we're going through this first settlement. And one thing that I've often found, sometimes judges prefer maybe that the parties have had these initial settlement discussions or not. So have you found that you've preferred, maybe should the parties at least entertain these initial discussions? What kind of, I know we'd alluded to earlier, well, the parties should be serious about settling. So does that mean we are in effect requiring them to have had some sort of discussion, or at least some sort of serious discussion in the past?
Most of the time, when a mediation would come in a personal injury case or a contract case, you would have had some discussion between the attorneys about settlement. Typically, that discussion has taken place and either the parties have reached an impasse, or they've reported to the court that they have not been able to get the case settled. They may have a trial date that's impending, and the parties will then go to mediation. I don't think it really makes any difference as a mediator whether or not they've had settlement discussions before they come to you or not. I think once they come to you, we need to know what the status of those discussions are. And certainly, and David had mentioned this, when you make the submission to the judge, you really need, or the mediator, you need to let that mediator know what the problems are in getting the case settled. Is it a problem with my client? Is it a problem with some of the medical being difficult? Is it a lien issue that we're trying to deal with? And I think if you will be as informative as you can to the mediator, that helps the process.
That's very helpful. So I think kind of with regard to that as well, on a similarly related note, many judges have filing requirements of, say, you may have to send an initial settlement letter, like discussing the case, discussing the parties' positions. So I know this is pretty frequent practice in the Northern District of Illinois. So Judge Jantz, is this a requirement you have in your courtroom? And if so, what have you seen in terms of effective, maybe like initial like set like letters like outlining your position to the court?
Yeah, so it's definitely a requirement of mine, and the requirement is there for two reasons, really. One, I need to be able to learn something about your case to be helpful to you. And so I'm really just looking for the basic facts in the law that would allow me to get up to speed on your case. In federal court, we see all kinds of cases, and lots of them we see a lot. Section 1983 or employment discrimination. But I had one this morning, it's copyright infringement. I don't know much about copyright infringement, so I've got to have the parties tell me a little bit about that. And so that's one letter, educating the judge. But number two, the other point of the letters is, I said this at the beginning, there's always going to be a canyon between the parties, but are we within striking distance of getting something done? Because it's a lot of preparation on my part. It's a lot of preparation on the part of the attorneys and the clients. And there's an emotional cost. In a lot of these cases, there's a lot of emotion. And to have a client sit down for a whole day and go through that, you want to make sure you have a shot. And so I triage those letters, I get them. And if, someone's at 2 million and another party's offering 15,000, and I've seen those, we're going to talk before we sit down, because that ain't going to work. So those are really the rules for it. In terms of effectiveness, there's no one way to do it. You're just getting me enough to be helpful to you, and you're putting your position on paper, clear. Here's the monetary, here's the non-monetary that we'll need. But I've seen it in all shapes and forms, and they're usually very, very good and very helpful.
Thank you so much for that, Judge Jantz. I mean, it really seems to just be important part is that it's neutral, that you kind of we're getting the court up to speed, at least on the case, both factually and legally. So I think Judge Bernthal, I know you've had a lot of experience with both settlement and mediations. So one thing I've been kind of curious about, so as you're going through the settlement or mediation process, how have you kind of run these types of proceedings? And what are you looking for during the conference? And Judge Bleyer and Judge Jantz, you can also jump in as well.
Well, I would gather the people in the courtroom, typically put on the robe when I was a judge, and give them a little explanation of how this was going to work, and remind them of the advantages of settling the case, and not do opening statements. I learned early on, or at least reached the conclusion early on, that those were not helpful, that the parties knew what the other side was thinking, and it only kind of polarized and hardened the attitude. So I stopped doing that. But then I would break into separate caucuses and either shuttle the people back and forth, or later, when I realized that was not as efficient, I would shuttle back and forth between their private caucuses. And having assured them that what they told me would be confidential, unless you authorized me to share, confidential from the other side, from the trial judge, and you couldn't call me as a witness under the rules, reminding them of that, then have some good heart-to-heart conversations. Sometimes I'd pull the lawyers aside privately and have a conversation. I would never talk to the client without the lawyer there. That's a no-no. And then, go back and forth, occasionally get everybody back in the same room. That's when you're kind of getting down to the go, no-go point. I didn't ever want to do that early on. I want to be able to let people speak freely, not worry about what the other side might hear. Frequently, if it was an individual plaintiff, it's very important to let the plaintiff vent and tell me how bad they'd been treated or how evil the other side was. And, you just let them do that. Try to establish some rapport so that when you really get down to the nitty-gritty, you've developed some trust. If you offer an opinion, which I usually didn't do unless asked for, they would give it a little more weight, because maybe hopefully develop that trust. That's the procedure in a nutshell.
Yeah, I would agree exactly that that is the procedure that is typically followed. And I think all three of us that have done mediations would tell you, though, that every case is different and you have to modify what happens in each case. And even as the mediation is going forward, the mediator has to make some adjustments as well on what's to be done. You know, one thing that I think that young attorneys particularly find difficult is understanding their role as an advocate for their client and at the same time being objective about the process. And, you know, it's difficult when you've got your client there to be anything other than an advocate. So I think that's why it's particularly important when you make your submission to the mediator or to the judge that you be an advocate, but you be an objective advocate. The judge, the mediator doesn't need to hear, well, we don't owe anything and here's why. You know, that's not helpful. So just be honest with the mediator, let him or her know at the beginning of the process and before the process what the good and the bad of your case is. And then I think it makes it easier during the actual mediation process to be straight with the mediator and at the same time let your client know that you are in fact advocating for their best interest.
Thank you for that, Judges Bernthal and Bleyer. So, Judge Jantz, throughout your experience, you know, even if you said you've been on the bench for a couple of years, have you found that when parties are entering into these settlement agreements, have you found that maybe there's a certain type of negotiation style that works best for it, maybe more cooperative? I know we discussed sort of balancing out being objective versus adversarial, but sometimes like parties will have a take it or leave it type of approach. Do you find that effective at all? So what have you kind of found has worked best?
So I've actually found that all different kinds of styles really work. It's really kind of a fun part of my job is to work with so many attorneys and clients, and they all approach it a little bit differently. I think we can all assume that, you know, being mean to our side or the judge is not a great idea, but other than that, I think a lot of different approaches work. I think there is a time and a place for sort of a take it or leave it, the sort of last, best, and final, if you really mean it. And sometimes parties really do mean it, and it can be effective when used strategically. You know, I think part of my job is to give people advice. You know, I do these things 3 times a week, sometimes more. And so I give people advice on how they might be able to achieve their objectives, and they're free to take the advice or not. But that's kind of what we're here for. Not only the substantive, but also sort of the logistics, the procedural, because we do it a lot. So I think it just depends. It depends on timing, it depends on the kind of case. But I think all different approaches are worthwhile at times and interesting for me to see, kind of fun.
Thanks for that, Judge Jantz. So basically, it just seems like whatever works best for you and what is most true to yourself and to your case is probably, I think, the most effective.
Very true.
Thank you, Judge.
Yeah, but also checking with your client, right? I think it's hard for me to know, again, because I haven't had enough people twice or 3 times to know if their sort of styles vary. But I hope part of the process is, you know, consulting with their clients and what are their clients comfortable with, but also sort of leading their clients and giving them good advice about what might work. And I often think that some of the approaches are driven by clients, and that's okay too, because that's what you're there for.
Yeah, I think that's important context as well, Judge Jantz. So, Judge Bernthal, so one thing we've alluded to kind of throughout this is like managing client expectations. Sometimes clients may have certain styles of negotiation that they would prefer to see. But what happens, say, for example, even if maybe despite the fact that your client initially wanted to enter into a mediation or settlement agreement, but maybe for whatever reason, things aren't going so well, and the client just is maybe not being agreeable with certain things, or is not budging. So what have maybe you done in that situation, and what is something that attorneys should be aware of if maybe clients are maybe deciding to no longer be amenable to negotiating, or just maybe are not willing to move past a certain amount?
And you do run into that. And that's hard to deal with no matter how many years you've practiced law. You don't want to lose your client's confidence. You don't want to lose your client, because they're quick sometimes to say, well, whose side are you on? You're trying to be objective to protect them from themselves. And you get the whose side are you on? Well, I'm on your side. Well, you should be pounding the table and talking tough. Well, that's not always the best course. I think it starts from the very beginning of the representation. What does this client want? I try to identify if they're not realistic. Employment law case. Well, I want the CEO fired and put in jail because of the way I was terminated. Okay, we're not going to be able to do that. You have to understand that. So that kind of, you start working them from the beginning. I noticed Judge Long, who's the magistrate judge in the Central District, it's probably a pretty standard provision, but he has in his order, tell the mediator, the mediating judge, you want a facilitative approach or an evaluative approach. That's good to know in advance. Plus, if you have that client, tell somehow, if you don't want to put it in writing, tell the mediator, look, I got a little problem here, because sometimes the mediator, if the mediator knows that or picks up on it, will be able to, if the mediator agrees, reinforce what the lawyer has told the client, and sometimes that helps. But there are those who just don't want to listen to anybody, and I usually will say, did and still do, look right at the client and say, you have a very fine lawyer, and that lawyer will do the best job he or she can do for you at trial. But I fear you're going to be disappointed. And when that happens, if it happens, don't blame your lawyer. You made a decision today. I respect your decision. I don't agree with it, but don't get mad at your lawyer, because you made the decision and you have to live with it. And sometimes they kind of recoil a little bit, and sometimes it helps. And sometimes we all want that mediation to end with a settlement right there that day, instant gratification. But sometimes it takes a day or so of thinking about something that was said, and suddenly things fall together. So that would be one other throw in for the audience, that don't give up just because it didn't settle that day, unless it's, you're still $10 million apart. Keep the embers getting a little oxygen. They may flare up again.
Thank you for that, Judge Bernthal. And I think that's an important thing to consider, is that sometimes it may not even be that day. It may not even be that conference. I know in some cases that parties may enter into mediations or settlement conferences multiple times. And maybe none of them will work out, or maybe it's the third or the fourth. So Judge Bleyer, I'd be curious to hear, in your experience, how have you kind of dealt with, maybe if you've seen the same litigants in the same case, maybe coming back for mediation or for settlement, and maybe how have you kind of seen that play out? And what would you advise attorneys do if maybe, okay, it's been a couple times, this is try number 3, like what should they be doing differently?
Yeah, and I think that is a good question, because that does come up. Unfortunately, it comes up many times when one or both attorneys or more of the attorneys just haven't gotten prepared for mediation. I've had situations where parties will come in and they'll say, well, here's what we think we have to have. And we've got this lien that's a substantial medical lien that we've got to deal with, or a work comp lien. And I'll ask them, well, what are you going to have to pay back on that? What are you looking at? Well, we don't know. I said, well, have you contacted the lien holder? Have you contacted the attorney for the work comp to discuss what would have to be paid back? No, we haven't done that. And I think when you have a situation like that and the attorney just hasn't done the homework they need to do, I try to learn that early on and just say, guys, it's going to be difficult for us to really get a settlement here until we have that information. So I try to cut it off early, let them get that information, and then come back. You get into a cost factor a lot of times where mediation can be a big expense, and particularly in cases where you have a limited value on the case, to come back multiple times is just not something that can be done. So it works. It can happen. There are times where the mediator, and I think it has to be the mediator that makes this decision and says, hey, I think we're getting close here. I think there's some things that need to be done. I suggest we come back, and that can be done and can be done effectively, I think.
Thank you for that, Judge Bleyer. Very important just to consider. So we have a question from the audience. This is specifically directed to Judge Bernthal. So earlier you mentioned the facilitator versus evaluator mediator approach. So can you explain maybe those different types of approaches a little bit more, and maybe in which circumstances those approaches may be helpful?
Okay. Yeah, my understanding is the evaluative approach is more after you've done your preparation and you've listened to the parties, you actually start suggesting numbers. Here's what I think the case is worth. Here's the range that I think is reasonable. The facilitative is you avoid that and you just keep the parties talking. You might point out concerns. You know, if I'm with one side, here's one of my concerns. Here we talk about risk. Here's a risk for you, and be assured I'm going to talk about risk to the other side. But that kind of thing. Keep them talking. Ask questions and hopefully make them think about, because they come in thinking there's no way we could lose, and you have to make them understand that it could go south at a trial. So those are the two, as I understand those two styles. I always preferred the facilitative because, you know, who am I to tell somebody what the case is worth? But sometimes you can, and it helps. If they tell you that in advance, you can kind of go into it with that mindset. So, you know, if you think you need that, you got a client who thinks their $100,000 case is worth 10 million, maybe you need that. And so coming from the neutral, maybe it carries a little more weight. Hopefully that addresses the question.
I definitely think it does. And very important things just to consider no matter what, especially as litigants, in terms of kind of also reading the room in terms of how the mediation is going, just in terms of fluidity, in terms of even maybe the types of questions that the judge may be asking you. So as we enter, say, as we start going back to in-person thing, whether we're returning to our offices or some courts are starting to go back to in-person hearings. So Judge Jantz, I wanted to maybe get your thoughts on maybe virtual, such as maybe through Zoom or telephonic mediations and settlement conferences. And I'd be curious to hear if the Northern District may be continuing these types of virtual proceedings, and maybe if that's something you generally see as like a trend that will continue like across the board.
Yeah, so I think in our courthouse, it's going to go judge by judge with his or her preference. I think a lot of judges are probably of the view now that this is a great tool to add to the toolbox, because I love in person. When I was a public defender, everything would always be in person, and I'm a big believer in it. When I was on the bench for about 6 weeks in person before the pandemic hit, did for a number of settlement conferences. So yeah, I have some benchmark, and I've seen no drop off in the success of settlement conferences or sort of the connection with these and clients over Zoom, or we use Microsoft Teams. And I think in a lot of cases, it's a really good tool to have, because you think about particularly clients having to fly into Chicago. That's really a 3-day trip, because you got to fly one day, be with me the next day, and then fly home. There's a lot of cost there. I think it's very difficult on attorneys and families who have family responsibilities, because they're gone for 3 days now. And sometimes people want it, and that's great, but it's not, I don't know that it's necessary anymore. It saves money, it saves attorneys time, and clients time. And so I plan to just going forward, offer the option of in-person or video, and I'm comfortable with hybrid. So one side can be in person and one side can be video. I'm fine with that too. I'm here for the parties. I want to make it as accessible to them as possible. And I've actually found that people are a little less antsy over the video, because they can have a suit coat on and jogging pants and go get a cup of coffee from their kitchen and go take their dog for a walk, and they're not stuck in my little jury room. So I think it's just a nice thing that we've all found is like, we can do this, and it's another format that works and works well in some cases. So I think it's going to be judge by judge. I plan to offer both, and whatever parties want to do, I'm down with it.
Yeah, I think that's actually very important. And I found actually pre-pandemic too, was that I found this for a couple of settlement assistance cases where I had represented prisoners with 1983 cases, was that the court was actually very amenable to doing hybrid, where maybe the plaintiff would be via video conference and I would be in person. So the fact that that was already even thought of beforehand, I think, is a sign that at least within a bunch of districts that we were already thinking about accessibility, which is good.
So the one caveat I would add, and I would be interested in what our other judges have to say about this, I'm not a fan of fully telephonic. One, I just can't read, and they can't read me very well without the visual. Two, I can't be sure everyone's paying attention, and sometimes busy clients maybe are not paying attention. But I'd love to hear from others if some folks make telephonic work, and that's great. I'd be interested in that. I don't personally do it, but maybe I'm missing something.
I with you, Jantz. I mean, I have found the same issues, and we've been doing a lot of the hybrid mediations as well, and that seems to work. I like in person. I like to be across the table and see somebody and be able to talk to them, but the reality in today's world is that that's not always possible. So we're making the hybrid work.
Yeah, I'm not a fan of just telephonic. The exception would be if you've had a mediation and now you have a follow-up that's only going to be on a limited issue, some back and forth. I'm okay with that. But with Zoom, well, I wouldn't want to do one that the whole mediation that was just by phone. The other thing, back to expenses, the Zoom or equivalent, you want somebody with settlement authority there. And sometimes that's going to be somebody from corporate and or an insurance representative. And, if they're coming from Connecticut, that costs, and that it impacts the schedule. And if you don't have them there, you can't really have a smooth mediation. But if you can Zoom them in, that problem is if not eliminated, dramatically reduced.
So thank you all three for those valuable perspectives. We do have a question from the audience, and specifically this person was asking, is the settlement assistance program only available in the Northern District of Illinois? And can attorneys that do not reside in Chicago participate via video? So Judge Jantz, I'll leave that to you. But Judge Bernthal, if there's similar programs in the Central District, I'll let you participate too.
Yeah, so I would definitely for Judge Bernthal on whether it's also available outside the Northern District, but for sure, you do not have to live in Chicago to participate in this program. It used to be that it was probably helpful because otherwise you might be traveling really far away to come into the courthouse. But now we're perfectly happy. I think speak for most magistrate judges, we're happy to have anyone help with the program by video, so location shouldn't matter. It's a little more flexible now. Hopefully that answers the question, that it's a little more opened up now just because of the travel logistics are less for our attorneys.
Yeah, it's a great program. And as far as I know, it's probably due to lack of personnel. I don't think they have it in the Central District unless they put it in recently, but I'm pretty sure they don't. But it's a great program. When I first heard about it, I thought, man, that's great. I wish we could do that, but we haven't, or we/they haven't.
Oh, go ahead.
Just thank you both for answering that question.
Of course. Thank you, Nick, for asking. One thing, obviously, just to consider too, is especially within the Northern District, obviously make sure you are at least a member of the general bar. So if that is something that you need to check in before volunteering for the Northern District of Illinois, all you need to do is just make sure you have 2 references. It's a very simple process to become a member of the general bar. So obviously just make sure you do that, or you pro hoc vice in beforehand.
Hey, Kenny, I had a question for the panel. And any of you are welcome to answer this, but Judge Bernthal kind of touched on it. In the past, I've always required an insurance adjuster, someone with a settlement authority, to be present. But I've also had situations where clients want to bring either a close family member or someone who they trust. Okay, that's always been my policy, but I was just curious if you'd ever, if that's a normal practice for mediators to limit to just the parties that are at issue versus those who might have an outside interest.
That's a great question. And, my response, I guess, already revealed how I feel about it. But sometimes the dad or the spouse can really get in the way. They're the ones that have got a brother-in-law in California who has a friend who just got a settlement for, and so that becomes the standard. And I don't know that I would want to prohibit the person from being present. I try to discourage having them in the room. And if I can't keep them out of the room when we have our private conversations, I try to, with the help of counsel, hopefully, encourage them to just sit quietly and listen and, be supportive. Don't try to take over. But it can be a real challenge.
Judge Bleyer and Judge Jantz, have you had those circumstances come up in your courtrooms or your mediation room?
Judge Jantz, if you want to go ahead and.
Sure. I don't have it come up too often, but I would, my view is you can't settle the case unless a plaintiff, him or her, or whether it's a corporation, a corporate representative, can say yes. And if that requires a comfort level with a spouse or a family member, to me, that is what it is. And I'm willing to work with that. I'm actually surprised it doesn't come up more often because these are financial decisions, and I don't know that I'd go buy a car without telling my husband what I pay. That's sort of normal family relationship communication. So it really doesn't come up that often, but if someone said, hey, I need this person to be able to settle, I'll make that work, because ultimately I'm looking for someone to be able to say yes or no that day. As our other judges have pointed out, sometimes it goes longer than the day, and that's okay too. So I'm flexible on it, but I haven't had it come up that often in the 2 years I've been doing it so far. But obviously these folks have much longer experience than me, and maybe been burned a few times and have, very good experience and points on this topic that I have yet to learn the hard way, perhaps.
Yeah, I agree. I've had it come up several times. Sometimes it can help the process. Sometimes it can be a real problem. And I think the attorney should be able to know which way that's going to be before you begin the mediation. And if there is an issue where his client, his or her client says, hey, I want to bring so-and-so in. If you think it's going to be a problem, just call the mediator, say, here's an issue I've got. My client wants to bring in a spouse. I don't think it's going to be helpful. Can I just let them know that that's not the way you want this to work? And, that's a good way to handle it, I think.
Thank you, guys. I appreciate that insight. Yeah, in the past where it's been kind of a requirement of the client, I've done my best to allow them to bring that trusted friend or family member with them, but try to keep them in the building, but maybe not involved in the discussions in a way that they can feel like they're participating and having that support. So I appreciate that as well. Kenny, did you have any other questions? We're nearing our time here as we approach 1 o'clock.
Yep. The only one last question I would just have for all of our judges is that if there's one thing that our members here should take away from today's presentation, what would that be? And I'll start with Judge Bernthal.
Consider mediation throughout. And if you go that route, prepare.
Judge Bleyer?
That's it in a nutshell. You've got to be prepared going in. You have to do a good job with your mediation submission so that your mediator, he or she, will be able to be prepared as well.
All right, and Judge Jantz.
So some law schools teach negotiation courses, but the bulk of law school isn't focused on settlement conferences or depositions or stepping up in court. You get some of that. And so I would just encourage, particularly if folks here in the audience don't have a lot of experience yet, find ways to get it. Because you don't know how to do something until you do it the first time. So whether you volunteer through the settlement assistance program or you're an associate, can you ask a partner to come along? I think most judges are incredibly receptive to having another attorney in the room, particularly one who's there and learning. They'll actually be nicer to that entire side, I think. So just find ways to get involved, speak up, advocate for yourself to get this kind of experience, because it's really fun and it's the way to learn to do this stuff.
Great advice.
Well, thank you all so much for sharing your time, wisdom, and expertise with all of us today. We greatly appreciate it. And we thank all of you for attending our fourth and final session of Food Court for the 2021-2022 bar year. So court may be dismissed, but we hope to see all of you in the future. And for all of our judges, thank you. And we look forward to the next time we see you.